Hey, good morning. Welcome to our second ITF webinar. This time is devoted to termination of intra-EU bilateral investment treaties, its legal and practical implications. So when we have our normal offline events, the time before the event and shortly after it, like a few minutes after it's supposed to start, is the most interactive because people keep chatting to each other, making new connections. But in the online format, it's a very silent time because we wait until everyone else joins. And I'm happy to see that we already have around 100 participants who joined, and hopefully there will be more on their way. The topic of this webinar is very important and it's very hot. And well, because you joined this webinar, I don't need to explain why it's important. Before we actually start discussing the issue of termination of intra-EU bilateral investment treaties, let me say a few words about the British Institute of International Comparative Law and the Investment Treaty Forum. So I'm Yari Krivoy. I run the Investment Treaty Forum at the Institute, and I am also Senior Research Fellow in International Economic Law. British Institute of International Comparative Law is essentially a think tank, but it does a lot of practical work as well. So we help governments to draft laws, we organize events, we do consultancy work, and we try to engage people not only from the United Kingdom, but also from outside of the United Kingdom. And the Investment Treaty Forum is a part of the Institute which deals with international investment law and investor-state dispute settlement. We have around 30 members, corporate members, and around the same number of individual members who are usually senior practitioners in the field. And just recently, over the last couple of weeks, several governments joined the Investment Treaty Forum as consultative members, including Trade Bureau of the Government of Canada, the Permanent Representation of the Slovak Republic to the European Union, the Legal Office for International Affairs of the Ministry of Economy of Mexico. And we hope that because we have more government involvement in our events, that will make them more interesting, more interactive, and hopefully the governments will also benefit. I would also like to thank those who register for our online course, International Investment Law and Dispute Settlement. If you would like to discuss discounts and for groups, then please let me know. The event today is going to be recorded, but we only record the presentations and not the discussion part. The presentation part will be subsequently published online, but the discussion part will not be published, will not be recorded, because the idea is that we want to have as honest interaction as possible to discuss very controversial issues. So this is why we don't want that part to be on record. The whole idea of terminating intra-EU bilateral investment treaties comes from the conflict between the law of the European Union and international investment law, in particular bilateral investment treaties, which provide for different substantive protections and for different dispute resolution mechanisms. After the European Union has enlarged, and even prior to that, various states of the European Union were concluding agreements between themselves. Most of those agreements are actually agreements between old member states of the European Union and newly joined members of the European Union. And the reason why we international lawyers, public international lawyers, look into these issues, because it presents a very interesting conceptual problem, how you reconcile different universes of international law. The law of the European Union, which is widely considered to be international law, and the law of international investment agreements. So if you look at the Vienna Convention on the Law of Treaties at Article 70, it seems relatively straightforward that state parties to treaties can terminate a treaty, any treaty, provided that it releases So this termination effectively releases the parties from any obligation under those treaties, and it should not affect any rights, obligations, or legal situation created through those treaties. So that's the general rule. However, this rule can be changed by the parties if the treaty itself, the termination treaty itself, provides for different consequences. And this treaty, which was concluded between a number of member states of the European Union, actually does that. So it terminates both substantive obligations and dispute resolution clauses. It also deals with sunset clauses. So it looks like a relatively straightforward termination to some people. But in practice, it's rather complicated because it also affects several disputes which are currently pending. And this, in practice, will cause difficulties, and some of the panelists actually already experience those difficulties. And another aspect of this problem is that not all member states of the European Union followed this approach, and the United Kingdom, which is no longer a member of the European Union, but is still supposed to implement European Union law during the transitional period, is also, according to the European Commission, failing to effectively remove intra-EU bilateral investment treaties from its legal order. So we'll also discuss that, and I know that we have representatives of the UK government as well in the audience. If they want to ask questions, they're very welcome to do so. However, I must add that all presentations are made in personal capacity. So our speakers do not represent the views of their clients or of their employers. So we will have 10 minutes for each initial presentation, and then we will open the floor for questions. And the way how we're going to handle questions is first, you will need to type your question in the Q&A box. You can find this box at the bottom of your screen. And this question then will be visible to all panelists and all participants, and people will be able to vote for those questions. So if you particularly like a question, then you can vote for this question, and then it moves up, and then the likelihood that it will be picked up by the moderator is much higher. So, and once the question is selected, then the person who is going to ask this question is going to be elevated or upgraded to the role of a speaker, of a panelist, which means that you will be able to use your audio and your video to ask your question directly to the panelists. So let me stop here and introduce the first speaker. You will be able to find detailed bios of the speakers on the event website, but let me just say that we're very pleased to have with us today Ms. Anne-Françoise Melot, who is the head of the Unit Free Movement of Capital and Application of EU Law in the Directorate General for Financial Stability, Financial Services and Capital Markets Union of the European Commission. We're very pleased to have you with us today, and Anne-Françoise, the floor is yours.
Thank you very much, Jarek, and thank you very much also for the invitation to participate in this webinar this morning. I'm very happy, and I look forward to the exchange with the participants. My presentation this morning will focus on 3 points. First, I will tell you what is the position of the European Commission on the intra-EU BITs. Then I will tell you in a nutshell what are the consequences of this termination agreement, which was just signed, as you said. And then finally, a few words about the system of investment protection in the EU. So let me start my presentation. While it's open, I think the position of the Commission on intra-EU BITs is well known. It's a long-standing position that, in a nutshell, is intra-EU BITs as a whole overlap and conflict with EU law. And as a whole, meaning that not only their substantive provisions, but also their procedural ones, including the mechanisms for the settlement of investment disputes. For this reason, the Commission has encouraged member states for many years to terminate their intra-EU BITs, and it opened informal infringement proceedings against 5 member states in June 2015. Then came the famous judgment of the ECJ in Achmea, which in March 2018 confirmed the incompatibility with union law of the investor-state dispute settlement mechanism of intra-EU BITs. And in particular, it confirmed the incompatibility with Articles 267 and 344 of the treaty. I'm trying to move my slides. For some reasons, it does not work, but it does not matter. Following that Achmea judgment, member states took a first concrete step in January 2019. So it was an important step. All member states committed to terminate their BITs as a whole by means of a plurilateral agreement or bilaterally if more expedient. So this was January 2019. Then in order to deliver on this political commitment, member states embarked into a long negotiating journey with the help of the Commission as a facilitator, as a coordinator. And Anna, who will speak this morning, can testify that this was a tough journey. She was part of it. This process was concluded earlier this month, on the 5th of May, with the signature of the plurilateral agreement on the termination of intra-EU BITs by 23 member states. So this is a big step which implements the Achmea judgment. By signing this agreement, those 23 member states confirm in an instrument of international law the formal and coordinated termination of 124 BITs. Once the member state signatories will ratify the termination agreement, which should happen in the next weeks or months, depending on their own national procedures. So once the ratification will be done, then their intra-EU BITs will be formally removed from the legal order. This termination agreement, it's important to say as well, is concluded by and between the member states. The EU itself is not a signatory. And yeah, I said that 23 signed, so who are the ones which did not sign? Austria, Ireland, Finland, Sweden, and the United Kingdom did not sign the agreement. So they did not go for the plurilateral coordinated approach, which was the preferred one. They did not go for this, but nevertheless, they are still under the obligation to terminate their BITs bilaterally. The 5 of them, the UK as well. And the Commission is, of course, closely monitoring their progress. And we have a tool, which is the infringement tool that we can use to enforce this if necessary. And you might know that on the 13th of May, the Commission has already sent letters of formal notice. So the first step in the formal infringement proceeding, we have sent letter of formal notice to Finland and the United Kingdom for failing to ensure the termination of their BITs. So now, in a nutshell, what's in this agreement? What are its consequences? So there are three blocks. First, the termination agreement clarifies that investors cannot rely on intra-EU BITs and that arbitration clauses in those treaties cannot serve as legal basis for intra-EU arbitration proceedings. In this context, it's important to say that arbitration clauses no longer apply as of the accession to the EU of both parties. And these clauses have become inapplicable since the incompatibility with union law arose, namely when the last of their contracting parties acceded to the EU. So in that respect, the termination agreement is purely declaratory. The member states clarify in an act of public international law how the conflict between union law and the BIT is to be solved in favor of union law. The second block now in the agreement is that it clarifies that intra-EU BITs are terminated as a whole, including any sunset clauses. This is also the case for sunset clauses that have already been triggered. And then the third block is about the claims made under BITs, where the termination agreement clarifies that concluded arbitration proceedings shall not be reopened. So we are talking about settlement agreements or final awards issued prior to the date of the Achmea judgment, 6th of March 2018. The termination agreement also clarifies that pending cases cannot continue and need to be withdrawn. What are pending cases? Those are the cases initiated before the 6th of March 2018, before the Achmea judgment, and which do not qualify as concluded arbitration cases under the definition of the agreement. So those pending cases cannot continue. And regarding those pending cases, there are a couple of provisions in the agreement. First, there is an obligation for the home and host member states to inform arbitral tribunals on the legal consequences of the Achmea judgment. There is also an obligation for national courts to annul any arbitral award rendered on that basis and to refuse to enforce it. And finally, the agreement provides two types of transitional measures for pending cases. The first one is the possibility to recourse to a so-called structured dialogue to solve those cases amicably with EU member states. And the second transitional measures is an access to national courts, which is possible even if the national time limits for bringing action has expired. And those two types of transitional measures, the dialogue and the access to national courts, are not mutually exclusive. And an investor may have recourse to either or both. So I think that's where I would stop for the termination agreement. And now, finally, you can skip the two following slides. Yes, can go to the next one. Thanks. Finally, a few words on investment protection after intra-EU BITs. Because the termination of intra-EU BITs, of course, does not mean that investors within the EU have no way to defend their interests. The Commission has recalled in a communication published in July 2018, the Commission has recalled the rules and the remedies at an investor's disposal under EU law, in particular, the free movement of capital, the freedom of establishment, the protection of fundamental rights, including the right to property and the right to conduct business. So we have already a solid framework under EU law. However, we have to admit that EU law does not solve all problems of investors, and we know that the communication did not alleviate all investors' concerns. We have heard feedbacks in workshops organized by the Commission in December 2018 and in December 2019. So for this reason, the Commission has decided to work on an initiative, on a policy initiative to improve, to reinforce the intra-EU investment protection. This has been announced in the Commission work program of 2020 and also in the Industrial Strategy for Europe published in March. So this initiative that we are working on would be composed of three pillars. The first one is about clarifying, filling gaps, modernizing EU rules protecting intra-EU investment. The second would be about the enforcement of these rules, how to improve the existing mechanisms. when there are disputes between investors and member states. And the third pillar is about measures to facilitate and promote cross-border investment in the EU. And of course, this is even more crucial, important now in the current COVID-19 outbreak. You have probably seen the Commission spring economic forecast, which expects that the economy will experience a recession of historic scale this year. The projection for FDI are dramatic drop. So in this context, fostering the investment within the EU is even more important than before. And I would finish with informing you about a very concrete step that we have taken. Last week, the Commission published on the 26th of May an inception impact assessment, which is available for comments until the 23rd of June. This document outlines briefly the problems to be addressed and the available policy options. And we have also published the same day a public consultation, which is open until the 8th of September to obtain feedback from stakeholders. And I encourage you, of course, to answer and to present your feedback and ideas to the Commission. My team is taking care of this job. With this, I thank you very much, and I give the floor back to Yarrick.
Thank you very much, Anne-Françoise, for your insider's perspective, and also for giving us an idea about the future plans of the Commission. And I hope that those who attend this event will also take part in your public consultations, and hopefully this event will also contribute to your future thinking, because we will have interesting questions, I'm sure, at the end. Now let me invite Ms. Anna Bilanova from the Czech Republic, who currently acts as a Deputy Head of International Arbitration Protection of Foreign Investments Unit at the Ministry of Finance of the Czech Republic. By the way, for those who want to tweet about our event, you can use hashtag ITF law, Investment Treaty Forum law, ITF law. Anna, please, the floor is yours.
Thank you, Eric, for giving me the floor and for the invitation to the webinar. First, I would like to state that the presentation is made in my personal capacity, and therefore my views are personal and do not reflect the official position of the Ministry of Finance of the Czech Republic. In my presentation, I will first start with outlining the Czech efforts and the Czech experience with the intra-EU BITs, and then I will focus on the Termination Treaty and its consequences. Czech Republic in the past concluded 25 intra-EU bids, and on the basis of those treaties, we have now still 4 pending disputes, and the 26 disputes were already concluded in the past, and the vast majority of them were won by the Czech Republic. We counted 2 losses. One of the biggest losses was the CME case, and the other one was the Eastern Sugar loss. But otherwise, we were fairly successful, and we have counted many victories in our disputes. The Czech Republic already in 2005 fostered the intra-EU objection and made the proposition to the arbitral tribunal in the Eastern Sugar case that the intra-EU BIT in that case shall not be applicable because the country has entered into the EU, and therefore those treaties were superseded by the EU law. However, the tribunal at that case, it was not sympathetic to the Czech Republic arguments, and it found against the Czech Republic, and since then the Czech Republic never succeeded with that objection, and therefore it was agreed by the government relying on the EU Commission recommendation. It was the DG Internal Market and Services that sent a note to the Economic and Financial Committee Council in 2006 to recommend the termination of those treaties. And the Czech government followed those recommendations and adopted a resolution already in July 2008, and in this regulation it was agreed that the mutual termination by consent is the best step, meaning that the BITs are terminated through a diplomatic exchange of notes and including the sunset clauses of those agreements. Over the years, the Czech Republic was fairly successful, and we succeeded in terminating 8 of those intra-EU bids. Already in 2009, we terminated the agreement with Italy and Denmark. 13 other intra-EU bids will be terminated by the termination agreement that was concluded this May. However, there are still some countries which decided not to sign the agreement, and Anne-Françoise mentioned those countries, and we will proceed with the bilateral termination with them. After Achmea, there were 2 possibilities for the member states how to tackle the new milestone judgment of the Court of Justice, and one of the possibility was to proceed with the bilateral termination or enter into multilateral negotiations. The multilateral negotiations at the end were seen as a preferred option, and European Commission organized meetings in its premises where the member states gathered and discussed the potential solution. The pros of this solution was that all of the concerned member states were on board, and of course it was seen as much simpler solution to conclude one agreement that would terminate eventually all intra-EU bids. The negative side to this approach was that the pool of the negotiation parties within the EU is quite broad. We are 28 member states that have to agree on certain points and articles, and therefore it took a bit longer than predicted. And as Anne-Françoise mentioned, the negotiations were made in 2 steps. First, the member states agreed politically that they are committed to conclude this agreement on termination, and they also agreed on other political commitments that I will not focus right now. And afterwards, they sat by the table together and concluded the termination agreement. And in my view, that termination agreement, termination treaty is a compromise solution of the member states. And the core provisions of that treaty are to be found in Articles 2 to 4, which stipulate that the intra-EU bids are terminated as a whole, including the sunset clauses, and also mentioning that arbitration clauses in those intra-EU bids cannot serve as a legal basis for arbitration proceedings. In respect of investment disputes, the contracting parties agreed that the termination treaty will not affect the concluded disputes and concluded settlements. And Anne-Françoise mentioned that the date where the concluded dispute is to be counted is the date of the Achmea judgment. And they also agreed that no new investment arbitrations under the intra-EU bilateral treaties are possible. The treaty also contains some possibilities for pending arbitrations in respect of potential judicial remedies or access to the newly established settlement procedure. However, I would like to stress that there are still some conditions that need to be satisfied so the investor can obtain the access to those solutions. And the first one is that the investor has not yet used the available domestic remedies. It was not a party to the domestic procedures, domestic proceedings. And at the same time, it withdraws and waives its claims from the arbitration proceedings. And in case it wants to get use of the settlement procedure, it has to request a suspension of the arbitration proceedings. Only on that basis, it can access those transitional possibilities. And in respect of this newly established settlement procedure, I would like to note that both disputing parties must agree on this procedure. And the aim of that procedure, this new settlement procedure, is to facilitate agreement in the pending arbitrations where EU law issues are present, which is visible from the text of Article 9, that there are conditions under which the state party shall agree to it, and it would happen when there was a national judgment stating the violation of the EU law. But at the end, the result of this settlement procedure, which is a written proposal by the facilitator, is not binding, though a party that doesn't want to agree to that proposal needs to provide explanation why the settlement is not possible. Therefore, in my view, the termination treaty marks the end of investment arbitration in Europe, because sooner rather than later, the investment arbitration based on these treaties will not be possible. And that means that existing investors will have to rely on existing domestic law and domestic remedies, and will have to seek the help of the national courts. At the same time, it is quite difficult to assess the whole impact on the investment climate, mainly because some investors might have concluded some other agreements or even investment agreements with member states, and they are protected under those contracts. Again, some of those pending arbitrations, they might be seated outside of Europe, and as of now, we do not have any judgment of the foreign courts stipulating on Achmea and denying enforcement on the basis of the Achmea ruling, and therefore the situation is still unclear, even though the member states agreed that they will inform even foreign tribunals that those awards are not enforceable. However,
sorry, you can go ahead.
However, the member states, they were mindful of the fact that after Achmea and after the termination treaty, there might be some lack of, there will be lack of those treaties and this extra layer of protection, and they started to discuss potential options in order the investors feel secure and protected in the EU. And I would like to point out that the termination treaty in the preamble already refers to the ECOFIN Council conclusion of July 2017, in which the Council encouraged the Commission to assess options for a modern European framework for the effective and binding resolution of investment dispute. And it also specifies that the member states shall intensify discussions without undue delay on the subjects. And as François also mentioned, these discussions have already started. The Czech Republic and the EU Commission has organized workshops for the stakeholders, and these stakeholders already expressed some concerns with respect to the investment climate. And last week, the EU Commission started a public consultation on the investment protection and investment climate in Europe, which is available until 8 September. And in that regard, I would like to urge you to maybe tell your clients about this consultation, because the data that will be gathered by the EU Commission and the member states might help us to agree on potential future solution. And to note, there are various options on the table right now, which are listed in the public consultation. And there are, for instance, that no new regulation is necessary because it will be evaluated that protection is sufficient, or the other option that is listed there is to create the EU ombudsman-like body, or even the EU investment court that will be modeled after unified patent courts. I would also like to draw your attention that the public consultation provides space for the public and for stakeholders to inform them about potential other solutions. So in that respect, I would also like to draw your attention to this, that the discussion has started, and there are many options on the table right now. To conclude, I would like to note that the Achmea decision should not be viewed negatively. I think that for a long time, the investment climate in Europe was not uniform, and there was unequal and divergent investment protection in various EU jurisdictions. And this is a right moment and an opportunity for us to reflect on existing legal framework and potentially innovate available dispute settlement options or create some new tools depending on the outcome of the public consultation. And with this, I would like to conclude and thank you for your attention, and I'm looking forward to any questions.
Thank you very much, Anna.
Thank you.
As a perspective from an EU member state. I should have mentioned that Anna is also involved in organizing a conference in Prague dealing with the international investment law, which I heard was very good. Let me now invite our next speaker, Matthew Happold from Luxembourg. Matthew is an ITF member and is Professor of Public International Law at the University of Luxembourg. It seems like he's the only person not constrained by loyalties to big corporations or governments or international organizations. So you can be perhaps more open as an academic. And so we very much look forward to your comments, Matthew. Thank you.
Thank you, Jarek. And just to join with the other speakers in saying I'm very happy to be here, albeit virtually, today to talk about these important and I think interesting issues. Now, every parent tells their children that you can't have your cake and eat it. But I think that's what the termination agreement rather tries to do. On the one hand, the termination agreement accepts that intra-EU BITs were not terminated by the accession of their EU 13 parties to the Union. And we've seen already Articles 2 and 3 of the agreement set out procedures for the termination of, I think it's what, 124 BITs listed in Annex 1, and for the termination of the effects at the sunset clauses and those other BITs listed in Annex B, which essentially seem to be BITs to which Poland and Italy were parties. Now, this all seems fine as a matter of international law. Parties can always terminate treaties by mutual agreement. As for the termination of the effects of sunset clauses, I think there are strong arguments for saying that that's effective too. I don't have time to say why I think that. Maybe that's something we can discuss in the Q&A. But to say a treaty is terminated, of course, implies that it's currently in force, and the centerpiece of these BITs is their investor state dispute settlement provisions, the arbitration clauses, and that's for obvious reasons. Preparing for this, I went back to Eastern Sugar and Czech Republic, which Anna's just mentioned. It's one of the first intra-EU BIT cases. And there the tribunal's very clear. The arbitration clause is in practice the most important provision of bilateral investment treaties. The investor's rights arising from the BIT's dispute settlement clause to address a tribunal independent from the host state is the best guarantee that the investment will be protected against potential undue infringement by the host state. And the tribunal goes on to say EU law does not provide such a guarantee. Now, the arbitral jurisprudence seems fairly clear. Such clauses express a unilateral offer by the state parties to the treaty to arbitrate disputes that might arise between them and nationals of the other state party concerning whether the treatment of the latter's investments by the former accords with the state's obligations under the treaty. Consent to arbitration is perfected by the investor's acceptance of the state's offer. It can not be retroactively invalidated by subsequent termination of the treaty. Now, that's set out at the beginning of our story in Eastern Sugar, in a series of cases arising out of Venezuela's denunciation of the ICSID Convention, and recently in other cases such as Magyar Farming Company in Hungary. So if the treaty was enforced at the date that consent was perfected, which is usually by initiation of arbitration proceedings, the arbitral tribunal established to determine the dispute has jurisdiction to do so, all other conditions, of course, being met. And now this is, of course, where the agreement tries to have its cake and eat it by arguing that arbitration clauses in intra-EU BITs are inapplicable. And so important is this position that it's repeated 3 times in the agreement. It's in the preambular paragraph 5, it's in Article 4.1, of which we've already heard mention, and it's in the statement in Annex referred to in Article 7. As a consequence, unless an arbitration is what's called an intra-EU, under an intra-EU BIT is concluded, that is fully executed prior to the 6th of June 2018, if procedures were initiated where both parties, the underlying BIT, were EU member states, it falls into the category of a pending or a new arbitration proceedings. And then, of course, Article 7, which we've already heard, applies. Article 7, it being purely declaratory, reflecting what the treaties, as interpreted by the Court of Justice, said, by the Court of Justice in Achmea say. Now here we, of course, move from the logic of international law to the world of EU law. Intra-EU arbitration clauses are inapplicable because they're contrary to the EC treaties. And this was made very clear by the January 15th, the declaration of January 15th, 2019, where the governments of the member states said that union law takes precedence over bilateral investment treaties concluded between member states. An arbitral tribunal established on the basis of investor-state arbitration clauses lacks jurisdiction due to the lack of a valid offer to arbitration by the member state to the underlying bilateral investment treaty. Now, in a footnote, the declaration also stated that the same results follow under general public international law, in particular from the relevant provisions of the Vienna Convention on the Law of Treaties and Customary International Law. Now that, unfortunately, I think can hardly be said to be an explanation, and it's not repeated in contrast to the EU law arguments in the preamble to the termination agreement. Indeed, the arguments made under general international law and the Vienna Convention, particularly under Articles 57 and 30, have been uniformly unsuccessful when presented to arbitral tribunals established under the arbitration clauses of intra-EU BITs. I think the only arbitrator who thinks that there's been a change is Professor Marcello Cohen. Now, why is that important? One, because arbitral tribunals enjoy competence, the power to determine their own jurisdiction. And secondly, in many cases, investors have had the option under intra-EU BITs to arbitrate under the ICSID convention. Now, to return to the termination agreements, I think matters don't actually end there. Reading it as a whole, I think it's clear that it's not, that, you know, the problem is not just with intra-EU BIT's termination clauses, but also the substantial protections they provide. Now, you might say perhaps that falls by the wayside. It's hard to see the relevance of the substantive protections without the dispute resolution proceedings, but we've already heard the Commission's position. But what you can see from the termination agreement is the idea that those protections, those substantive protections, apply even prior to termination, continue to apply even prior to termination, is strenuously resisted. It's apparent from the beginning. I think it's the 8th paragraph of the preamble provides that this agreement is without prejudice to the compatibility with the EU Treaties' substantive provisions of intra-EU BITs. But it's most obvious as regards the alternatives to arbitration offered to parties to pending arbitration proceedings in Articles 9 and 10 of the termination agreement. Now, Article 8.4 is clear. Any resolution of dispute, including an amicable resolution, must comply with union law. And you might say not objectionable. You need to deal with situations like that in Mikula, where it's alleged that paying an award would be unlawful state aid. But if you read Articles 9 and 10, I think it goes even further. It's not just that solutions must be compatible with EU law, but they must be based on EU law. And indeed, they must be based on EU law to the exclusion of the consideration of any provisions in the relevant intra-EU BIT. So if you look at Article, I can't go through these in any detail. If you look at Article 9, which deals with structured dialogue for pending arbitration proceedings, Article 9.10, just to give a flavour, it states that impartial facilitators must take due account of rulings of the Court of Justice of the European Union and decisions of the European Commission, and must take into consideration the case law of the CJEU on the extent of reparation for damages under Union law. In other words, that's what the yardstick should be as to any damages that should be recovered. It's the same as regards, in fact, Article 10, it's even more obvious access to national courts. Claims may only be based on national or EU law. No claims may be brought under the provisions of any intra-EU BIT terminated under the agreement. Now you might say, well, it will be terminated by then, but there you are. And it seems to be that what's being pushed, you might say the situation is back to what would be if no BITs existed. You're having to seek a remedy for the national courts by reference to national law, whatever the deficiencies of those judicial and legal systems. And I don't have time to describe those at the moment, but you can look at judgments of the European Court of Human Rights. You can look at the Commission's own annual Justice Scoreboard. You can look at recent infringement proceedings brought by the Commission as regards to judicial independence. Now, for an investor, I think that means that if you accept the logic of the termination agreement, it's pretty much all stick and no carrot, which leads me to think that many of them will simply, particularly if they're proceeding in arbitrations under the ICSID Convention, simply think it's worthwhile keeping going. They're insulated from national court challenge. And if they can't enforce any award that they might receive in the EU, well, they can always look to enforce it elsewhere in Switzerland, in the United States of America, and after the 31st of December in the UK. How much time have I got left? I think I'll just say one thing, that the fact we're in this situation is the only responsibility for this is the EU member states. A session of the EU 13 dates back to 2004, 2007. Croatia's 2013. The award Eastern Sugar, which I've just referred to, dates back to the 27th of March 2007. Now, the Czech Republic has actually taken action. It has sought to terminate its BITs by mutual agreement, but many member states simply haven't. And as Marie-Françoise has said, that led to infringement proceedings in 2015. The Achmea judgment didn't come out of nowhere. It was the consequence of a political failure. And that political failure, I'm afraid, continues, as we can see by the fact that only 13 of the 27 member states signed the withdrawal agreement, and that the Commission's announced infringement proceedings against Finland and the UK less than 2 weeks later. So yes, is this the end of investment arbitration in the EU? Possibly not, but it is definitely the beginning of the end. Let's hope something comes. At the moment, I think the alternative presented to investors with pending arbitration, even new arbitration proceedings, I think there are only 4 of them under the termination agreement, are unattractive when they exist. And the promises made for better future treatment are at that only promises. I've got a few questions myself, but I'm going to end there. So hopefully at least I've raised some issues, if not answered them. Thank you.
Thank you very much, Matthew, for this overview and raising so many controversial issues, which are not that apparent if you look at the agreement from the first sight. Now let me invite Charles Claypool, who is based in London, and he works for Latham & Watkins. He's a partner at this law firm, which is a member of the Investment Treaty Forum. He has significant experience representing both states and investors in international in investor-state disputes. Charles, your 10 minutes.
Thank you very much. And let me join the other panelists to thank you, Jarek and Bickel, for setting up this very timely and important and interesting webinar. Following on from disclaimers of others, what I'm going to say now is obviously my personal capacity. And what I'm not going to try to do is to predict how tribunals might analyze and interpret this treaty. But what I'll rather do is focus on practical steps that practitioners and their clients are likely to take when faced with disputes that might be impacted by this treaty. I'm trying to get some slides up now. Is that okay, Jarek? Yeah. I can't. Okay, well, I think I can't move the slides, but anyway, firstly, I'm going to say something regarding the impact of this treaty on future investments within the EU, some of which will inevitably result in legal disputes. And then I'll discuss in more detail some of the likely issues that will relate to the impact of this treaty on pending intra-EU arbitrations. And there I'll distinguish between what the treaty defines as pending arbitration proceedings, and those are those initiated before Achmea, and those which have been initiated since Achmea. Those are defined as new arbitration proceedings. So just turning to the first issue. Now, I think we're all familiar with the European Commission's position on the protections contained in BITs and the extent to which they may be protected under EU law. That was discussed to some degree by Anne-Françoise earlier on today. Now, the Commission's view is reflected in the preamble to the treaty to some degree. You'll see there reference to the fact that when investors from member states exercise the freedoms of establishment or the freedom to move capital, those investors enjoy certain protections under EU law, including those which are guaranteed by the EU Charter of Fundamental Rights. Now, the question of whether those protections are covered by or equate to the protections typically found in BITs is, I think, a matter of some debate. It's clear, I think, that national restrictions are required to comply with fundamental rights which correspond to those guaranteed by the European Convention on Human Rights. But to say that the Commission's position as set out in its paper on the protection of intra-EU investment, that those protections are an adequate substitute for the protections found in existing BITs, at least as developed in the jurisprudence of investment treaty tribunals, is ambitious, and it sounds like that will be an issue that's going to be discussed in the consultations that were referred to earlier on. But that point aside, I think we can all agree, and this was a point made by Professor Happel just now, that a key advantage of the investment treaty system is the fact that it provides investors with the option, and it's an option, of enforcing those rights directly against host states before a neutral arbitral tribunal, and potentially recovering damages that should in principle reflect the full value of their losses. The alternative is to rely on remedies available before domestic courts. And I don't think that it would be too controversial to say that investors with investments in certain EU member states lack confidence that they will receive not only effective judicial protection, but also the possibility of obtaining before those courts prompt and full compensation for their losses. Indeed, if that were the case, I doubt that there would be many intra-EU treaty arbitrations in the first place, and we probably wouldn't be having this discussion. And I think the recent action of the Commission that was just referred to initiate infringement proceedings against Poland on the basis of the lack of independence or perceived lack of independence of the Polish judiciary would indicate that those concerns have some justification. Now, I think the result of all of this is the treaty seen against the context of the Achmea decision and subsequent actions of the European Commission is likely to have the presumably unintended effect of placing non-EU investors possessing investments in the EU that have treaty protection in a preferential position to intra-EU investors. And what will the consequence of that be? Well, I think it can be fairly anticipated, at least until the various policy initiatives which were referred to earlier have resulted in new law, that sophisticated companies investing within the EU, which should have the benefit of international legal advice, will structure their intra-EU investments via a non-EU country in order to obtain investment treaty protection. Now, that possibility wasn't referred to earlier, hasn't been addressed in the recent treaty, but would seem to be a likely consequence of the current situation. Now, turning to the impact of the treaty on ongoing arbitration proceedings, the starting point, as referred to earlier, is Article 7, and that mandates respondent states to notify arbitral tribunals seized with pending arbitrations that they lack jurisdiction, or in respect of pending court proceedings, that the award should be set aside or annulled since it's based on an inapplicable arbitration agreement. Now, in those pending proceedings, as a matter of practice, it's likely that the host state has already done that, and the chances are that the Commission also will have intervened in those proceedings and filed its own submissions. So it's unclear what impact Article 7 will have. Now, Article 8 then goes on to say that where an investor is a party to what the treaty defines as pending arbitration proceedings, those are arbitrations initiated before Achmea, so long as the investor has not challenged the measure that is subject to the dispute before the competent national court, the transitional measures in Article 9 and 10 that have been referred to earlier apply. Now, I won't say much on these transitional measures, but I mean, I think there's a few important comments need to be made from a practical perspective. So Article 9, if you have a look at it, it really provides for a form of mediation or conciliation. Article 9.1 requires the investor first to suspend any pending arbitration or court proceedings, and then to request the respondent state to enter into a settlement procedure, which will be facilitated by someone required to have an in-depth knowledge of EU law. So what it really is a form of EU law mediation or conciliation. Now, it's unclear how Article 9 will work in practice, and it's doubtful or unclear whether it will actually be invoked in the procedures followed. Article 9.1 would indicate that it's optional, but Article 9.3 states that a settlement procedure shall be entered into if a national or EU court has held that the measure in question violates EU law. And Article 9.4 provides that a settlement procedure shall not be entered into if a national or EU court has held that the measure does not violate EU law. It's unclear how those provisions would interact in practice. If an investor has successfully invoked EU law in challenging the contested measure before domestic courts, it would follow that the investor cannot invoke the Article 9 procedure, but it becomes compulsory if a domestic court finds that the measure violates EU law. But in that case, does that mean that the investor would no longer have the opportunity to claim damages before national courts, or is it obliged to follow this mediation procedure? The other transitional provision, Article 10, also gives rise to a number of issues. You have an investor that has an impending claim that was submitted to arbitration before Achmea, or if an investor already has a favourable award, the treaty appears to stipulate that the investor should waive its rights as a condition of being granted access to the courts of their member state, not a suspension, a waiver. Now, given that access to justice is a basic and fundamental right, I think it's contentious and perhaps contrary to human rights law to suggest that such access should be limited in the way that this treaty appears to indicate. Article 10, as was mentioned earlier, also purports to dispense with national law limitation periods that might otherwise bar new claims. But it's unclear whether or how domestic courts might apply this, which is, after all, a treaty provision, not a provision of EU law. What would happen here if an investor decided to waive its claims under a BIT or an arbitral award, only to find that a domestic court then found its claims to be time-barred? Even if there were to be a possibility of a reference to the CJEU, that provision introduces considerable legal uncertainty. Now, that's a very brief overview, but I think it's fair to say that this treaty, including its transitional provisions, raises a number of quite serious problems from a practical perspective. And I think we can all see how its attempt to stifle intra-EU arbitration claims based on causes of action that have already accrued, so based on arbitral agreements derived from mutual consent that has been perfected, which are governed by international law, by independent tribunals that, as Matthew said, have competence, gives rise to some quite serious issues. Just turning to the practical perspective again, it would seem that a claimant in a pending arbitration proceeding under an intra-EU BIT would have the following main options. So first, for arbitrations that were initiated before Achmea, Article 8.4 expressly states that the investor is free to resolve the dispute with the host state amicably, but with the proviso that any amicable resolution must comply with the EU law. Given the clear position of the Commission that arbitration clauses contained in intra-EU BITs are inapplicable, it's difficult to see states in pending arbitrations being willing to settle these disputes on terms that might be acceptable to investors. And of course, there's the risk that any payment of compensation could be regarded as illegal state aid. So that's settlement. Second, you've got the option of the Article 9 mediation procedure. But for an investor to invoke that, as I just mentioned, it must agree to suspend the arbitration proceedings, which of course it might not want to do. And it's clear that in this procedure, the facilitator will consider the merits of the claim, not from the perspective of international law, but from the perspective of EU law. So I think it's fair to say that few lawyers will be advising their clients to proceed on that basis. Third, you've got the alternative of challenging the contested measure before the national courts. But as I've just discussed, Article 10 provides that an investor may only be entitled to access domestic remedies before national courts on a number of conditions, including that the investor waives all rights under the relevant BIT or in respect of any award that's been rendered. So that doesn't seem particularly attractive. Now, the other alternative, which obviously goes against the purpose of this treaty, is that the investor may proceed with the arbitration and attempt to enforce a favourable award that it might obtain in a jurisdiction outside the EU, as Matthew just anticipated. Now, the situation is even less certain with respect to those pending arbitrations which were initiated after Achmea, of which I think there are 4 before ICSID. The treaty only refers to amicable settlement and challenges before domestic courts in respect of the pre-Achmea initiated arbitrations, but it seems odd for those options to be excluded. The Article 9 mediation process is clearly not available for these claims, so it would seem that the only realistic option available to investors will be to proceed with their treaty claims. So just to sum up, it's unclear how this treaty will in practice impact pending treaty arbitrations based on intra-EU BITs. It seems doubtful that investors in pending claims will invoke the transitional provisions contained in Article 9 and 10. On the other hand, it seems likely that respondent states will invoke this treaty in objecting to the jurisdiction of tribunals in those cases, or to resist the enforcement of awards rendered against them. As I said at the outset, I'm not going to try to predict how those claims will be resolved, but I think we can fairly anticipate that tribunals will analyze this new treaty very carefully from the perspective of general principles of law, including the principle of non-retroactivity, principle of res inter alias acta, It will consider it from the perspective of treaty law and how it interacts with the ICSID Convention, and perhaps other areas of international law, such as human rights law, insofar it might be perceived to interfere with an investor's acquired rights or ability to access justice. I think, following on from what Matthew said, it's doubtful that this treaty will be the silver bullet that the Commission and some of the member states clearly want to stifle ongoing intra-EU arbitrations, but rather it might just introduce more legal uncertainty, more litigation, and presumably, at least until an adequate substitute is put in place, more dissatisfaction for investors who are likely to see this as an attempt to interfere with their ability to access international justice. Thank you.